Well, good morning. Good morning, everybody. My name's Stephen Wood. I am the director of the Center for Law and the Environment at the Allard School of Law in the University of British Columbia. Welcome to our first no-fly zone talk of 2023 with Canadian lawyer Danielle Gallant, who will be speaking about Generation Climate Action, the youth-led charter case against Ontario. The No-Fly Zone speaker series brings legal thinkers and actors from around the world to speak virtually about pressing environmental law issues, and it fosters national and global knowledge exchange without generating travel-related greenhouse gas emissions. I, the Center, and the law school are uninvited guests on the traditional, ancestral, and unceded territory of the Musqueam Nation. It's worth noting in connection with today's talk that Indigenous peoples steward much of the world's remaining biodiversity and experience some of the worst impacts of climate change, and that Indigenous children and youth around the world are in the vanguard of young people's movements for climate justice, including being amongst the plaintiffs in the case that Danielle will be speaking about, and also bearing the brunt of the impacts of climate change. Today's talk is being recorded. It will be available on the website of the Center for Law and the Environment, which you can find at allard.ubc.ca/CLE. If you have questions, go ahead and type them in the Q&A window at any time. You can see questions as they're posed, and I'm not sure if we activated this setting, but I'm hoping you'd be able to upvote questions that you like to bring them to my attention as the moderator. After Danielle is done speaking, then I'll moderate a Q&A session. You'll notice that I'm not alone in the room where I'm at. This is also the meeting of a seminar here at Allard Law School on green rights and warrior lawyers. And that explains the other people who are with me in the room. Danielle is a lawyer with Ecojustice, Canada's largest environmental law charity. Ecojustice uses the power of the law to defend nature, combat climate change, and fight for a healthy environment for all. Danielle joined Ecojustice in 2018 as part of the climate team. She is one of the lawyers representing 7 young people in Mathur et al. And Ontario, which argues that the province breached youth and future generations' fundamental rights when it rolled back its 2030 climate change target. Danielle holds an Honours Bachelor of Social Sciences, a licentiate in Civil Law, and a Master of Laws with concentration in Global Sustainability and Environmental Law from the University of Ottawa. During her master's, she focused her research on the intersection between environmental justice and rights-based climate litigation, which is exactly what she's working on now. And Danielle is a member of the Barreau du Québec and the Law Society of Ontario. Danielle, over to you, and I am going to turn off our video and mute our mics so we don't become a distraction while you're talking. Welcome.
Great, thank you for the wonderful introduction. I'm just going to take a moment to share my screen. And just confirming, perhaps you can unmute yourself for 1 second. Just let me know if you can now see my PowerPoint.
We see your slides.
Awesome. I will go on then. So thank you so much for this invitation to speak today about Mathur et al. Versus Ontario. I've been working on this case ever since I began at Ecojustice. So it's something that's very close to my heart and has been going on for a few years now. So it's really wonderful to see it progress to the next stage. So you've already mentioned I work for Ecojustice, which is Canada's largest environmental law charity. We have offices throughout the country in Vancouver, Calgary, Toronto, Ottawa, and Halifax. And I should mention that I come to today from Ottawa on unceded traditional territory of the Algonquin and Anishinaabe territory, which is obviously known as Ottawa today. And so you've already mentioned our mission to use the law to defend nature, combat climate change, and fight for a healthy environment for all. And so that is what I do in my job. So what are we talking about today? In terms of the Mathur case, we will talk about what the case is about, first of all. what has happened so far. We'll talk about kind of the full context of the case outside of the courtroom. And then I'll talk about my experience of working on a case like Mathur. Finally, leaving some time at the end for questions. And that's reminding me, I will start my stopwatch so I can keep tabs on how long I'm speaking for. So what is this case about? First of all, the who. It's being brought by 7 youth who at the time where we launched the case were 12 to 24 years old. They're from across the province of Ontario. They have kind of different lived experiences, from different places. And they're bringing the case on behalf of all Ontario youth and future generations. So they're seeking public interest standing to do so. They're not bringing it on their own behalf. And the case is being brought against the government of Ontario. So what are we challenging in this case? In 2018, Ontario introduced the Cap and Trade Cancellation Act, which I will refer to as the CTCA. And in doing so, it scrapped its previous legislated targets to reduce GHG emissions, also known as its climate targets, that it previously had for 2020, 2030, and 2050. And when it did this, it replaced those targets with one 2030 target. It's vastly inadequate, and it did so in its Made in Ontario Environment Plan, and it did it pursuant to the CTCA. So the CTCA mandated Ontario to set a new target in the plan, which it did. For context, the previous 2030 target was 37% below 1990 levels, which if you move it on to a 2005 baseline is about 45%. The reason for that is that Ontario increased its emissions between those two baseline levels. The new 2030 target is 30% below 2005 levels. So there's approximately 15% difference, but it also means an increase of 200 megatons from the previous target. And we argue that in doing so, Ontario violated youth and future generations' rights under the Canadian Charter of Rights and Freedoms, namely Section 7, the right to life, liberty, and security of the person, and Section 15, equality rights. And I'll get to that in a moment to explain further. And why we say this is because Ontario's 2030 target blows through their carbon budget for 1.5 to 2 degrees Celsius. So no matter how you put it, if it's 1.5 or 2 degrees, they blow through their carbon budget. And this is at a time where through the Paris Agreement, there's this political consensus throughout the world that we need to limit global warming to 1.5 to well below 2 degrees Celsius. At the same time, we have scientific consensus that through the IPCC, the Intergovernmental Panel on Climate Change, that 1.5 degrees Celsius avoids the worst impacts of climate change. And finally, more recently in the Glasgow Climate Pact, countries and parties also resolved to pursue efforts to limit to 1.5 degrees Celsius. But this is also problematic because Ontario's 2030 target is in line with global warming of as much of to 3 to 5 degrees Celsius if all jurisdictions took the same approach as Ontario. And we know, and we established this through expert evidence, that global warming above the Paris Agreement threshold will cause an increase in all sorts of climate impacts, including extreme heat events, wildfires, flooding, infectious diseases, algal blooms, and toxic contamination in Ontario. And these impacts will in turn cause an increase in deaths and affect the physical and mental health of Ontarians. And in turn, these impacts will then disproportionately affect young people, youth, and future generations because on the one hand, young people and youth are particularly vulnerable to the physical and mental health impacts of climate change. They are disproportionately affected. But they will also, youth and future generations will bear an increased burden of climate impacts because those impacts will increase in both frequency and severity over time. And finally, within youth and future generations, the subset of Indigenous youth and future generations are particularly at risk given the many intersecting vulnerabilities that they face. And that is why we bring also the argument on the basis of Section 15, the fact that these impacts will disproportionately affect these groups. So what are we seeking in this case? The how. We seek, first of all, declarations that the target violates Ontario youth and future generations' rights under the Charter, but also an order that Ontario set a new science-based target, which is consistent with its share of reduction needed to limit global warming to the 1.5 to 2 degree threshold. And finally, in order that Ontario revise its climate plan in accordance to this new target. In order to make our case, we're relying upon a significant quantity of evidence, including reports from 17 different experts detailing things like the various impacts of climate change on Ontarians, but also explaining how Ontario will bust through its carbon budget, but also relying on government reports from Ontario itself and from Canada, which detail the harms that are already occurring and that are set to occur in the future. And finally, authoritative IPCC reports that have been signed on to by governments that really lay out the foundational science of the case and the climate impacts that we're talking about. So what has happened so far? We launched the case in 2019, and fairly immediately, Ontario brought what's called a motion to strike, which is a motion that argues that the case is certain to fail and therefore should not move forward. And it argued this because it said that the case was not justiciable, which means that it's not appropriate for the courts to weigh in on this matter because, for instance, it's too complex or too political in nature. They also argued that our case is founded on unproven speculations about future emissions and climate impacts. And so there's no way that we could possibly know what future emissions will be and what the climate impacts will be. They also said there's no positive constitutional obligation on Ontario to prevent climate harms. And for those of you who are familiar or unfamiliar with the idea of positive versus negative rights, they're basically saying this is a case about Ontario's duty to act rather than action that Ontario has taken, which violates rights. And finally, they said that the applicants don't have standing to speak on behalf of future generations. I won't get into our own arguments because thankfully they mirror a lot of what Justice Brown found in her motion decision when she rejected Ontario's motion in its entirety, finding that the target and plan are reviewable, they're government actions, and they can be reviewed for compliance with the charter, and that the application is justiciable because it really challenges very specific government conduct. And this is important when we think about some of the other cases that unfortunately have been thrown out at the motion to strike phase, at least for now. She also found that the claims are capable of scientific proof and are not based on unprovable speculations. In particular, she took a look at what was found in the GGPPA reference cases, including by the Supreme Court, and found certain findings of facts that were made by the Supreme Court. And so said, you know, these same findings of fact are possible to be made by a merits judge in this case. She also found that the fact that the case may be based on positive rights, which she didn't necessarily weigh in on, she said even if it is based on positive rights, and that the claims are novel, that doesn't mean that it should be struck. This is something that should be heard through to the merit stage. And finally, that the applicants do, at least at a preliminary level, have standing on behalf of future generations. And she found that this case is of public interest in that it transcends the interests of all Ontario residents, not even just the applicant's generation or the ones that follow. So very positive motion to strike decision. And it's also a historic decision because it was the first time that a court had not struck out a climate case based on charter rights in Canada. And Ontario did seek leave to appeal the decision, which was denied. So it confirmed that this is the first charter-based climate case in Canada to survive, apologies for my typo, survive, a preliminary challenge or hurdle in Canadian courts. And therefore, the case moved forward to a hearing on the merits, which actually happened this past September 2022. So again, this is the furthest that any case on this basis has reached in Canada. And it was also the first time that a Canadian court would weigh the important evidence of climate impacts and determine whether on that basis, government climate actions violated fundamental rights. And this also meant that because we proceeded to the merits stage, we could see the involvement of interveners whose perspectives are obviously very important to the case. And so 6 interveners applied to be involved in the case, and they were all granted leave. So those include all of those that you see on the screen. And just to give you an idea of the types of different arguments and perspectives that were being brought, Indigenous climate action, for instance, argued that Ontario's target has particularly devastating impacts on Indigenous peoples and youths. violating their charter rights, and that Indigenous legal traditions should be recognized as part of Canadian law and inform the interpretation of sections 7 and 15. Friends of the Earth, for instance, argued that foreign jurisprudence, so cases throughout the world like Mathur, show that it's possible for constitutional remedies to be brought for climate-related harms. And also argued that there should be a new unwritten constitutional principle of ecological sustainability that underpins these issues. Assembly of First Nations argued that Ontario neglected its duty to consult and accommodate in establishing its new target, and especially that the target had adverse effects on First Nations, and that international human rights and UNDRIP also demand minimum standards that are not being met here. For Our Kids, which is a group that acts on behalf of children and grandchildren to protect the environment, promoted the consideration of the best interest of the child principle, and CAPE, or the Canadian Association for Physicians for the Environment, brought a perspective around the causal connection between Ontario's actions and the health impacts that were being caused. And finally, the David Asper Centre for Constitutional Rights spoke to the fact that the applicant's remedies are within the court's competence to order. So as you can see, all of these different perspectives and arguments were super important at the merits stage. So what happened at the merits? And we're about halfway through, and I know we want to get to the Q&A, so I'll hopefully get through this pretty fast. But on the merits, in our factum, in the first instance, we set out the important facts of climate change. So the fact that Ontario is contributing to climate change by exceeding its fair share of the global carbon budget and aligning itself with global warming of as much as 3 to 5 degrees. And in doing so, is exceeding the Paris Agreement temperature standard, which, as we know, will cause devastating impacts in Ontario. We also set out important legal arguments, like the fact that the application is justiciable because, again, as the motions judge said, it targets specific government action, the target and the plan, which were both taken pursuant to legislation, the CDCA. We're also arguing that it is, in fact, a negative rights case because this is not a case where Ontario has not acted and we're seeking that they do. It is a case where Ontario has acted in a way that violates rights. But even if the court did view this case as a positive rights case, it fit the exceptional circumstances for positive rights left open. In the Gosselin case, there's no greater threat to rights this century than climate change. And so it should be recognized as fitting those exceptional circumstances. We also argued there's a sufficient causal connection between the conduct and the harms, which is an essential part of the Section 7 test. And finally, that the harms do engage Section 7 and are contrary to what are called the principles of fundamental justice. Again, another part of the Section 7 test, because they are arbitrary, they don't actually bring about significant climate action, and they're grossly disproportionate to the impacts that will be caused. And we also argued a new principle of fundamental justice of societal preservation. So essentially saying Ontario's actions are undermining the preservation of society and cannot be allowed to subsist, as well as Section 15. On the other side, Ontario's factum pushed back on some of the facts that we had set out. So for instance, saying that Ontario's share of emissions at 0.3% to 0.4% is insignificant on a global scale, given that other emitters, and especially large emitters, also emit within that context, right? Back. And that this contribution is an immeasurably small impact on global temperature increase. And that, in fact, in Canada, emissions are regulated by the federal government, as confirmed by the carbon pricing reference decision at the Supreme Court. And Canada itself has a plan and a target for 40 to 45% nationally. So it actually doesn't really matter what Ontario does. In terms of legal arguments, they argued that the application is not justiciable because there are Canadian precedents on climate change. For instance, Environnement Jeunesse, La Rose, and Médéric, which are 3 cases that have unfortunately either been struck out or otherwise failed at a preliminary time. And that if it was justiciable, there are no judicially manageable standards. So there's no way for the court to weigh in on things like what's a fair share and what is science-based. They also argued that there's no causal link between Ontario's conduct and the harms, since there's no evidence to quantify that impact, and the target itself does not cause emissions. It's just a target. And finally, they brought up this argument again that it's based on a chain of speculative assumptions that cannot be proven. Finally, it's a positive rights case. The conduct is not contrary to the principles of fundamental justice because it balances environment and economy. And so, it cannot be contrary to those principles. And finally, that the Section 15 claim, the equality rights claim, is not really a claim based on age as the applicants advance, but rather a temporal distinction or an age cohort, rather than the classical definition of age that you'd see in Section 15. So we replied to that, correcting some of the facts in our view. In particular, that Ontario relied on two experts who we say lacked credentials and credibility. That the applicants have quantified Ontario's contribution to global climate change, but actually don't have to meet the Bedford sufficient causal connection test. That the federal target and plan rely on provincial emissions reductions, including those of Ontario, and so Ontario's emissions certainly do matter. And finally, that in terms of judicially manageable standards, the Paris Agreement standard is that global consensus, both political and scientific, that I was talking about to limit dangerous climate change. So it is a standard that the court can employ. We also argued, again, here the application is fundamentally different from those other non-justiciable precedents because it targets specific government action, and that Ontario's position in terms of how it contributes to climate change is not in line with the sufficient causal connection test. In many different cases, government action was found to not have to be the only cause of the harm. And the fact that third parties also contribute to the harm does not diminish Ontario's role. And that their chain of speculative assumptions argument misstates the case and ignores the significant evidence that we put forward. And finally, we argued that Ontario did not seek to justify the infringements of the Charter under Section 1. So that was the legal side of things, and maybe just here to kind of conclude on that, we had the merits hearing in September. We are still awaiting the decision, and we don't know when we will receive it. We're anticipating sometime in the spring or summer, but actually, it can come out as soon as today or tomorrow. We don't know, and so we're just waiting for that decision and to see what happens on the merits. But that is really only one side of this case. The full context is the fact that, this case has impacts beyond the courtroom. It has impacts on the public. It's an important way to inform the public about the way that the government is handling climate change and the impacts that this conduct will have on fundamental rights, especially those of youth, Indigenous youth, and future generations. And so this case has also been about elevating the voice of the 7 youth and all youth generally who will be impacted by climate change. Because in essence, this case is about their right to a livable future. And so it's really been about the general context of the issues and not solely about the issues that are being discussed in the courtroom. And on the screen, you'll see that we held a big rally right before the hearing, which was really wonderful to see tons of people come out in Toronto in solidarity with the youth and really brought forward, people from various different groups and different contexts, but all in support of this cause. And so I think that's an important thing to keep in mind, that climate litigation is never truly only about the litigation, but also the broader context. And finally, if I can talk a little bit about my experience of working on a case like Mathur, and I think many of these reflections extend further to my experience generally working as a public interest environmental lawyer. It's very interesting to deal with the challenge of a novel case, dealing with the particularities of climate change, which may not always fit neatly into the existing categories of cases and tests. So it's a really great challenge to try to apply the law as it is now to issues of climate change. It also involves interacting with climate science and other disciplines. And personally, I do not have a background in science. And so I found this particularly challenging, but also very important to be able to make legal arguments on the basis of the evidence that I did understand it. So it does require quite a bit of work to be able to interact with those other disciplines. Another challenge is communicating the issues efficiently and accurately to the judge and to the public. These are very complex, layered issues. And so ensuring that you have full understanding, but are also being able to translate that complexity into something that will be understandable to the judiciary, but also to the members of the public. And finally, these are public-facing cases. They involve heightened media attention. I didn't necessarily understand in law school that this could be a part of my role, but working on these types of cases does mean that you are called upon more to speak to students like yourselves or to the media, because there is this public interest nature of the case. And so that is a big part of the role as well. And just taking a step further back, as a climate advocate, I think it's a really interesting opportunity to use the skill set that I've developed through law school and through various practical experiences to work on something that's very impactful. So I don't take that for granted. I really appreciate the opportunity to do this type of work. But I will say there can be negative impacts to being involved in this type of work, working on heavy issues like climate change, and the impacts of climate change on rights. It can take a heavy mental toll, something to keep in mind. And I think as a newer lawyer, it's definitely always a challenge to get past this imposter syndrome, because you're working with people who are very experienced, very specialized, talented people. And so it's sometimes hard to feel like you can play a significant role in this context. But I've also had some really great colleagues who've helped me kind of develop that confidence in myself and know that I'm contributing to this great case. And finally, it's really a wonderful opportunity to work with incredible and passionate youth. Working with them has really been so far the highlight of my short career. Working with knowledgeable experts who've taught me so much, and finally with talented lawyers. And so it's a really great space to see and to see this amount of talent and expertise. So I think I'll leave it there. I'll just quickly mention that if you are interested in knowing more about the case, we do have a case page on our website. So I put the link there, but you can also access it through just Googling Ecojustice Mathur case. And you can also sign up for email updates if you'd like to just know what we're doing and what's happening. And if you want to know other ways to support us, please feel free to take a look and consider, applying as a student or a lawyer to work for us, because it's a great place to work and have excellent colleagues. So just wanted to throw that out there and now leave it up to questions.
Thank you so very much, Danielle. Thank you for your presentation and the great work that you do. Let's take an opportunity to express our appreciation through applause and the thumbs up and various other reaction buttons that are available. It is now time to have some questions. And I'll just remind folks in your Zoom controls, if you're joining via Zoom, there will be a Q&A button at the bottom that you can use to post a question. I will see them, and I see that we've already got one question, so we'll go straight to that. We prefer if you post the questions in the Q&A rather than raising hand, because to be quite honest, I'm not sure I would know how to unmute participants to let them speak. So apologies for that. So do post your questions on the Q&A. Although we do have the students in the room who can pose questions orally. The first question is from Klaus Maciel, who says, "Dear Madame Gallant, I'm a lawyer in climate litigation in Brazil, currently living in Quebec. In Brazil, some initiatives in this sense are already building some good precedents. I congratulate the group for the presentation and ask, is there any time estimate for a decision on the merits of this claim to be issued by the judge in this case? And will there be a hearing where we can watch the discussions in court? Or I guess in this case, would the court be issuing a live stream of the presentation of the judgment?
Yeah, that's a good question. In terms of the timeline, this is really just our own estimations that it might come out in spring or summer. We don't quite know. It can really come out at any time, but that's kind of what we're considering as probable. In terms of whether or not the decision would be live streamed in any way, I doubt it, but obviously this is something that would remain to the parties to decide, but I think no matter what the decision would be, there's a certain likelihood that it would proceed to an appeal in front of the Court of Appeal and then to the Supreme Court. And even the merits hearing was live streamed. And so I would assume that if it continued on to further appellate courts, it would also be live streamed, which I think is also a very important element of keeping the public informed and letting them attend the hearing. Also, for instance, our clients, they're from multiple places throughout the province, and so it might not always be feasible for them to come to Toronto for the hearing. And so I think that kind of access to viewing justice is very important. So I do hope that these kinds of things continue to be live streamed. And just because there was kind of an element about other jurisdictions working on climate cases, I can say that it's very helpful to see how many decisions have been rendered in other countries, other jurisdictions. We certainly drew upon those cases in our own arguments to show, for instance, these types of issues are justiciable. Courts have weighed in on them before. Courts have, for instance, weighed in on things like carbon budgets. And so it's very helpful to see these precedents from throughout the world, like Urgenda in the Netherlands and Neubauer in Germany, the Future Generations case in Colombia. So there are all of these cases throughout the world that can help, we hope, support victory in jurisdictions like Canada.
Yeah, and I would just add that it's not very common for Canadian courts to live stream the presentation of decisions, unlike some of the other climate cases we've seen, like the Urgenda decision, which was live streamed, the Sharma decision, which was live streamed in Australia. If the decision is appealed and there are further arguments, those would very likely be live streamed. As we're waiting for another question, Danielle, can I take a prerogative to ask a question of my own? One of the things that really struck me in a negative way about this case was the evidence and arguments that the lawyers for the province of Ontario felt it was appropriate to advance. So things like the arguments about justiciability, where clearly this is a charter case raising justiciable questions. The argument that they made both in the preliminary phase and in the current phase that this law and the target and the plan were just, quote, a glossy brochure. They had no legal effect. Even after having argued in another legal case that these were the law and policy that represented Ontario's binding commitment to take action. Raising the de minimis defense that you argued, Ontario's contribution is insignificant. They also raised what I call the drug dealer defense, which is if we don't do it, someone else is going to do it. Someone else will make these emissions, which would wipe out the impact of anything we might do. Even a nihilistic defense. There's nothing we can do. We're doomed. So nothing Ontario can do would make a difference. And in terms of the evidence, as you sort of hinted at, putting forward as experts known partisan climate deniers, or at the very best climate delayers as their experts. Do you think there are any ethical limits as lawyers to what sorts of evidence and arguments can be put forward, and where do you think those limits are?
That's a really good question. And I mean, I can only speak to it from my perspective, not having the perspective of the lawyers for Ontario, but, from our side, I think the way that the evidence was presented did set us up to be able to bring these arguments of credibility and bias. Like if there's any interest in seeing our factum, we have various paragraphs that set out our arguments about this, but, really pulling out their various affiliations, pro fossil fuel development, questioning the underlying science and the methods of the Intergovernmental Panel on Climate Change, which really represents this kind of global scientific consensus. So kind of opposing yourself to this consensus science, there's really, I think, a lot of scope for us to then push back at that evidence. And I think also the fact that our own evidence really came from scientists who all had very developed expertise. A lot of them are the leading scientists in the world, part of the IPCC themselves. And so, we hope that comes through in the way that we've argued our evidence. But I agree. I think a lot of what they said mirrors what governments often argue in climate cases, especially de minimis. We've seen it come up, I'd say, in pretty much every single case. And thankfully, even in a case like Urgenda, with the Netherlands being a relatively small country, that de minimis argument was rejected. And Ontario actually has similar emissions levels to the Netherlands and large countries like Argentina and Algeria. And so being able to push back on that narrative and show that in other parts of the world, countries with similar emissions profiles have been, this de minimis argument has been rejected, I think is helpful to be able to show. And I agree, I think we also pulled out the fact that a lot of the narratives that were being brought forward in Ontario's evidence did relate to this climate delay doctrine, and one of our experts actually opined on, what the various ways in which that manifests itself and how it can be tied to Ontario's argument. So I agree, this idea of there's nothing we can do. It's very complex to make these changes. These changes will take too much time, et cetera, can all be related to those kind of those narratives that we've seen again and again from governments and corporations.
Thanks. There is another question in the Q&A, and after that, I'll see if there are any questions in the room. So this is from an anonymous attendee saying, given the lack of success in previous climate cases in Canada, what pressure do you feel having this case's success and Ontario's climate accountability resting on your shoulders as an advocate? So we're all relying on you. How do you feel about that pressure?
Well, thankfully, first of all, it's not just me. There's a team of lawyers, and so that pressure is kind of shared between us all. But I'd say a lot of thought was given in framing this case in a way that would not run afoul of these kind of questions of justiciability and positive rights, to really focus on concrete, specific action that Ontario took. It set a law, the CTCA, and then within that legislation, it had to set a new target and a plan. And so it acted in relation to that legislation. And so there's really this kind of key distinction, not that I agree necessarily with the decisions that were made on the other cases, the Rose, that said that those cases were trying to, really go up against too broad and too diffuse state action, really kind of going after every action that inaction that the government had made. And so I think there's that key distinction that really makes this case about specific state action, and also means it's not a positive rights case. It is about action that Ontario did take that violates rights. And so hoping that in the merits decision, it remains to be seen, but we're hoping that the same kind of logic that the motion to strike judge found in distinguishing our cases from those cases will be replicated.
Yeah, and I also think that, it's significant that you aren't alone. There are people across the country and around the world advancing claims for government accountability for violating people's rights to a stable climate system. I think it's, the way I look at it is that this case is part of a global movement, and there's many different cases going forward, and at any one time, one case might be farther ahead than others, but there are always others coming up behind, and there are others who have gone before. And of course, there's also the support for the people in this case itself, Sophia and the other kids have thousands of other youth, children and youth and adults supporting them. Shall we see if there's any questions in the room? Anyone want to hazard a question? There is another one in the queue which I could ask, so I'll do that. Okay, so there's a question from Cheryl Milne asking or saying there's an emerging body of literature and a community of practice focusing on child rights strategic litigation that looks to whether this type of litigation is conducted in accordance with principles of children's rights. Can you tell us more about the engagement of the actual children and youth litigants in this case?
Yeah, I can say, absolutely. Thank you for that question. It's a great one. I'd say, in this case, we tried to provide every opportunity for the applicants to kind of be involved in the case itself. They had to, for instance, provide affidavits in which they set out their experiences and interest in being involved in the case, and that was part of the evidence that we put forward on this case. And so I think there was really this emphasis on, we're representing children and young people, and so we have to ensure that their perspectives are being heard and put in front of the court. And that was also achieved, just symbolically through the hearing was live streamed, as we said, and initially it was only supposed to be the lawyers in the room, and we received kind of special permission for the applicants to appear right at the start so that the judge and Ontario's lawyers and kind of everyone watching would put a face, the face of the young people being affected by climate change on these issues. And so throughout the process, we really focused on how we can involve them throughout the process. And so I think that's been really helpful also to see their perspectives and to see how we can incorporate those perspectives better in the way that we argue the case. So I think that's been partially a challenge. It's not usually the types of clients that we represent, but also presented a really great opportunity to become better lawyers and better advocates for their rights on their behalf. But I also know, as Cheryl mentioned, this kind of community of practice is developing throughout the world. So I'd be very curious to hear more and obviously continue to do better as we continue to represent these applicants or maybe others in the future in a way that pushes forward child rights in general. So it's a great question.
Yeah, and of course, the case is all about advancing the rights of children, but it's always important to think about how the case is assembled and how it's litigated and so on in a way that affirms child rights of the children who are the face of the lawsuit. I'm going to give the last question to Margot Young, who has posted a question in the queue, and then we will close just about at the 45-minute mark. So Margot asks whether you can talk about how this case may differ from the La Rose children's climate case, also in process in Canada now.
Yeah, absolutely. And I obviously I'm the lawyer for the Mathur case, so I'll speak about what I know and hopefully not get anything wrong. So the La Rose case is being brought, I believe, on behalf of 15 youth against the federal government. So our case is against provincial government, Ontario, theirs is against federal government, Canada. A lot of the similar legal arguments in the sense that I believe their case is also based on section 7 and 15 of the charter. I might be getting this wrong, but I believe they're also bringing in questions of the trust doctrine. So a lot of the same kind of legal arguments. And I think the key distinction for how the motions to strike in both cases have been decided so far is really what is being challenged. So in our case, as I've mentioned a few times, so sorry for repeating myself, but based on legislation and action taken pursuant to legislation, the target and the plan. So very kind of narrowly defined state action. Whereas in the La Rose case, and similarly in the Mitsiik and the Ontarians Charter-protected case, other cases that were brought against the federal government, it was a broader spectrum of government actions and inactions that were being targeted, kind of a setting of targets throughout a longer period of time, missing those targets throughout a longer period of time, and kind of a broader kind of spectrum of how the government has or has not acted pursuant to climate change. And from my understanding, that's what the court, the federal court in that decision kind of picked up on and found that it was kind of they called it a broad and diffuse challenge to state action. I don't necessarily agree with that because, I think how else are you going to be able to challenge the kind of broad array of state actions? But that is in the end what distinguished it from our case. And I will say, I think there's this kind of developing understanding of kind of framework climate cases where if you go after a target, the target is very specific, but it also represents the government's kind of whole response to climate change. And so that's a way to kind of narrowly specify litigation, but still kind of represent not just like one project approval, one decision, but the government's kind of broad approach to climate change through that distinct separate state action. So I hope that makes sense. And I'll also say, I know the La Rose and Midziek case are proceeding to an appeal of their motion to strike decisions. So hopefully those will be overturned, and then we'll have further cases that are also proceeding to the merits in Canada. And I believe those cases are being heard February 14th and 15th. So fingers crossed for them.
Oh, thanks for that. I wasn't aware of the specific date. Yeah, certainly I think it's really important to remember that even though the La Rose case was dismissed on the motion to strike, that decision is under appeal. So the case is by no means dead. It's still very much a live issue. And it's quite possible that a court at the appellate level will accept the argument that the counsel in La Rose have, asserted very eloquently that it is possible to challenge the government's sort of entire system of action and inaction or conduct related to climate change without falling afoul of, this problem that you have to challenge a law, you have to challenge an identifiable government action. Well, at that point, I will say thank you once again to Danielle Gallant for joining us. It's been such an informative session. I feel kind of overwhelmed by a wave of information that has swept over us, and really hopeful about the decision that may come down from the court and for the future of climate accountability in the province of Ontario and beyond. So I hope everyone will join me in thanking Danielle one more time.
Thank you again for the invitation.
Thank you for joining us. And thank you everybody online for joining, and the recording will be available on our website. But at this point, we will say goodbye. Goodbye, everyone.